It's very good to be with you. I'm sorry I'm not with you in person, but let me start by acknowledging the traditional custodians of the land on which we're meeting and their elders past, present and emerging. I've been asked to introduce matters to you, talking about the stigma for persons living with HIV, particularly in the context of the law. Let's be clear to start off with then what stigma is. It's often defined as a discrediting attribute of significance which serves to devalue people who possess that attribute, resulting in a loss of status and social rejection. The US Centre for HIV Law and Policy has made a useful contribution in this context, talking about the stigma arising from and related to HIV as being a significant public health problem. Now, the ways in which they identify that are in respect of the creation of obstacles for people living with HIV in obtaining treatment, housing, education, and employment, all of which, of course, are vital for their health. And they make the point that because HIV and the behaviours or identities associated with it remain stigmatised, confirming or disclosing one's HIV status is still widely perceived within the community as socially dangerous. And the issue again is that HIV-related stigma discourages testing and prevention and creates confusion and misinformation about the roots and relative risks of transmission of HIV. This has many facets, as everyone will be acutely conscious. The Centers for Disease Control, again in the United States, have generated a useful language guide in relation to stigma and HIV. It's worth having a look at, I think, because language matters in these contexts, doesn't it? When we talk about HIV, they say certain words and language do have a negative meaning for people at high risk for HIV or those living with it. And what the point that they make is that we can do things to reduce, I'm not sure it's stop, but reduce HIV stigma by being reflective and aware when we use particular words. And ideally, we should choose words which are supportive rather than stigmatizing when we speak about HIV. And it's interesting, if we go back a decade, how different the language was, which we utilized routinely when speaking about HIV. The law plays a role in all of this. There are a range of different factors which contribute to stigmatization and discrimination in respect of persons living with HIV. Now, the most obvious, of course, is when HIV-specific offences exist in statute books. An example was Section 19A of the Crimes Act in Victoria, which has now been abolished. But one of the themes that I want to leave with you is that even the significant victory in getting rid of a provision, such as Section 19A, doesn't wholly solve the problem, because people can still be charged. And that's so right throughout Australia, with communicating HIV in a variety of circumstances which are still criminalised. Another example is that from October in 2017 in New South Wales, a person with an STD, including HIV, is no longer required by law to disclose that they have such a condition prior to engaging in sexual intercourse. But if they know they've got it, they must take reasonable precautions to prevent transmitting the condition to others. And that remains sitting in the public health legislation of New South Wales. Now, there are reasons for it, but there's a flow-on effect in terms of ongoing proliferation of stigmatisation in respect of HIV. Discrimination on the basis of HIV status can be both direct and indirect. It can be formal, it can be informal. Formal discrimination in respect of HIV status is precluded in all jurisdictions in Australia. That means that disclosure of HIV status is not required in the workplace and if coerced, is unlawful and discriminatory. And there remain some exceptions. For instance, when a health worker is carrying out exposure-prone procedures. In 2018, the HIV Futures 8 report surveyed a significant number of people who were HIV positive from throughout Australia. And they found that just under 16% of people responding had experienced less favourable treatment at a medical service as a result of disclosing having HIV. And the point that that report made again was that discrimination, anticipation of discrimination, and a sense of stigma affects people's capacity to access health care in a variety of ways. Again, no surprise, but worth acknowledging and identifying if we're going to work through measures to reduce the nature and incidence of stigmatization. And HIV discrimination is often indirect. We can think of the overt, explicit, problematic examples of it. But for instance, it's only latterly that Police Scotland has said that it will stop marking people with HIV as contagious in their intelligence database. And this arose from a charity having identified the issue, and HIV Scotland saying that the change was one they were quite content to make. But then they, of course, had to apply pressure to Police Scotland, and it was successful. And HIV status is no longer being logged, and the marker for contagiousness, another stigmatizing word, they accepted had been applied to anyone who they knew had received treatment for HIV at any stage. So an indirect form of discrimination, but an important and problematic one. Now in Australia, the best known case to do with discrimination and stigmatisation by the legal process is that of X and the Commonwealth, the 1999 decision that ended up going all the way to the High Court. X had enlisted in the Australian Army knowing he'd be tested for HIV and would be discharged if he tested positive. Well, he did test positive, he was discharged, and he complained to the Human Rights and Equal Opportunity Commission that he'd been discriminated against by being discharged. And at the time, of course, when it all came to light, his health was excellent. Now, he succeeded before Heriok. The Commonwealth applied to the Federal Court unsuccessfully, and then they appealed to the full court of the Federal Court, and they were successful on that occasion. And then X appealed to the High Court, where he lost by majority. It remains an important case because the issue arose under Section 15.4 of the Disability Discrimination Act, which said that discrimination was not unlawful if it took into account certain matters and all other relevant factors it's reasonable to take into account had been, but because of a disability, the HIV positive status, the person would be unable to carry out the inherent requirements of the particular employment, or would require services or facilities not required by others, and that would impose unjustifiable hardship on the employer. Now, the point about this is that it created an opening for discrimination, and a substantial one. And ultimately, the High Court was split about it, but it was split with a pronounced majority finding that the decision of Heriok was wrong and accepting the decision of the full court of the Federal Court. And what that meant was that the Army was able to have regard to all manner of situations in which the inherent discharge of duties in the Army might be rendered problematic by the existence of a person having HIV. Justice Kirby, perhaps not surprisingly, dissented powerfully, saying common sense suggests that consonant with the will of the Parliament expressed in the legislation, it would have been possible in such a large field of the Commonwealth's employment to find particular employment for X that could have been carried out without unreasonable risk to ADF personnel or unreasonable burdens for the ADF. So this left an opportunity and a likelihood of discriminatory conduct in this important area. Interestingly, just latterly, a few weeks ago, Britain announced plans to allow people who've tested positive for HIV to join the armed forces if they no longer carry a detectable amount of the virus. Now, what this is responsive to modern clinical knowledge about treatment for and management of HIV. And it's something that we haven't replicated in Australia as yet. And so what you have is a contrast between enlightened British practice and anachronistic Australian practice. The reason I've identified that is just to highlight that these things take time, but the only way in which change happens is if there is lobbying for it and advocacy in respect of it. And an example of where that worked was in respect of persons who were HIV positive in the Victoria Police. And this was another success story. In 2017, Living Positive Victoria persuaded Victoria Police to abandon a proposed policy which would have required recruits and serving police to disclose any diagnosis with any blood-borne disease, but it was always about HIV, and to require blood testing where a medical officer so advised. It was a fraught, sensitive exercise, but advocacy resulted in a moving back from what was going to be a highly discriminatory and distressing process for many persons. There's all manner of legislation which is relevant to this, and I'll only advert to one or two examples. But HIV/AIDS vilification is against New South Wales law. And what that means is that it's a criminal offence to engage in a public act that could incite hatred, serious contempt, or severe ridicule toward people which have HIV or AIDS. But that legislation is not replicated throughout Australia. There are a variety of public acts which are identified in the legislation which criminalises this kind of conduct. It's an interesting contribution in an active sense to trying to reduce or maybe even eliminate discrimination in the HIV and AIDS area. So to conclude and to try to set the scene for some of the discussions that you will be having, it seems to me that the battle against HIV discrimination is really all about attitudes, often attitudes born of fear, misconceptions, and a range of prejudices. What we need to do is to work on multiple fronts to try to erode each one of those phenomena. Part of that is the deployment of neutral and non-discriminatory, non-stigmatizing language. There remains so much education still to be done, but the law has a major role in this as well, to try to avoid stigmatization and discrimination, both in terms of the words in legislation and practices adopted. Each one of these issues needs to be addressed separately and cumulatively. And the better this happens, the more successful advocacy is in respect of the real existent phenomenon of stigmatization of persons living with HIV, the more likely it is that discriminatory conduct can be reduced significantly with all of the public health advantages that flow from those improvements. I wish you well for the conference.